Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back now on the Rahimi case. Now, I've had an opportunity to go through it and tear through it a couple of more times, and I recognize that there's, varying opinions out here in the YouTuberverse. Some of my colleagues think it's not a big deal at all. Some of my colleagues happen to think it's the worst ruling that ever occurred in the history of the United States Supreme Court. I come down on the side that the ruling itself did not surprise me, but I am disappointed by the inclusion of a lot of problematic language. But now that I've had a chance to really geek out on it, I've come to a conclusion that maybe this is a big fat nothing burger, and I'll explain what I'm talking about. I'm going to rely on 5 points to make that argument. So today, let's spend a few minutes, let's geek out on the opinion again, and let's talk about why Rahimi did not change a damn thing. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, here's what we're talking about. We're talking about the case of United States v. Rahimi. I love doing these videos a week or two after the rulings have gotten out because it gives me a chance to actually go through the opinion a couple of different times, take a look at some other case law, tune out what some of the other people are saying, and really kind of come to a more objective and kind of hash out with you what this opinion is all about. As we know, this was an 8-1 decision which upheld the constitutionality of 18 United States Code Section 922G8. Now, I'm going to make 5 arguments here, and the arguments are going to basically get to the point that, hey, I don't think Rahimi changed the damn thing, and we got a long way to go on this issue. Okay, first of all, for any of you who were shocked that the ruling came out this way, understand that if you'd gone to law school, you would also know that bad facts make for bad law. They teach you that when early in law school, and it really does ring true. Secondly, you should have gotten a clue when the United States Supreme Court accepted review of this matter, that they in all likelihood were not accepting review to rubber stamp what the Fifth Circuit has done. We knew that there would be at least a partial, if not complete, overruling of what the Fifth Circuit did. If the Supreme Court was in complete agreement with the Fifth Circuit, they wouldn't have needed to waste their time taking this case, right? Second thing, while many on the left were really hoping that the Bruin test was going to get significantly watered down, that did not occur. However, there is the inclusion, as I mentioned earlier, of a lot of problematic language. We don't need a historical identical twin. We just need something relevantly similar. And I'm telling you what the gun-grabbing left is going to do is anything in God's universe will be relevantly similar. But for those who really thought that there was going to be announcements of new rules of law, yeah, that did not happen. And that's why I also believe that we're going to see the Illinois assault weapon ban cases likely GVR'd because of some of the re-announcements of the standards set forth under cases such as Heller and Bruin. Third, yes, there was some admissions and language chosen by the liberal justices in their dissenting opinion that may come back and haunt them later on. In most particular, Justice Sotomayor's language, should an assault weapon ban end up before this current makeup of the United States Supreme Court. The fourth thing, Justice Ketanji Brown Jackson may grow into her position as a Supreme Court justice, but right now, it would appear that she is clearly in over her head. When you take a look at her dissenting opinion here, when you take a look at some of the things that she talked about in Loper Bright Enterprises v. Raimondo, it is very obvious to me that Justice Brown Jackson believes that many of the court's duties should be delegated to other people. She makes a consistent complaint that how can the court possibly take a look at the history? That should be up to historians. They are the ones that should be advising the court. Now, understand, Justice Brown Jackson, that we're talking about the history of the Second Amendment. And I would also point out that you and all of your colleagues will also routinely rule on issues involving economics, involving politics, involving environmental regulations, and a litany of other things. And the last time I checked, none of you were experts on that either. But fifth, and finally, and this is the point I am trying to make, despite the fact that this ruling may be shoved down our throats, or at least some of the language, this is an incredibly limited ruling, and it's a ruling that doesn't solve really any of the complaints that we have about red flag laws or civil anti-harassment orders or protection orders or anything of that nature. And the reason for that is that despite the fact that there's 100-something pages here, this case really boils down to one rule of law. When an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment. Okay, so here's the point. The Supreme Court has ruled that the finish line, that is, if a person is deemed to be a threat to themselves or others, they can be disarmed consistent with the Second Amendment. That disarmament, that finish line is constitutional. Here's the question. What lane do we use to get to that finish line? Because it does not come remotely close to answering many of the questions that still need to be answered as it relates to red flag laws, civil protection orders, civil anti-harassment orders. Now, as a side note, Rahimi's attorneys waived any of the procedural challenges at the lower court. So it's not like the United States Supreme Court shirked their responsibility or ignored those issues. Those issues were never before this court. And why Rahimi's counsel chose to do that, I do not know. I'm not being critical of it. There could have been some very legitimate strategical reasons for doing it that way. I'm going to defer to them. But the bottom line is we have not come anywhere closer to answering these questions. Like, if we're going to disarm a person, what's the standard of proof? If we're going to disarm a person, what kind of evidence must be presented and how is that evidence to be presented? If we're going to disarm a person, what type of procedural due process are they actually going to be afforded, which includes notice and a meaningful opportunity to be heard? So if we're going to disarm a person, are we going to make their accusers take a witness stand and subject them to cross-examination, or are we just going to allow them to submit declarations? Because I can tell you, after being a trial lawyer now for 25 years, it is very difficult to cross-examine a piece of paper. And then, what is the level of danger that needs to be assessed before we're willing to disarm a person? I get when we have a red flag hearing, because most red flag hearings actually operate on the premise that it must be proven that the individual poses a threat to themselves or others. But when we start getting into some of these civil protection orders, or worse yet, we start getting into some of these civil anti-harassment orders, which are nothing more than neighborhood pissing contests that nobody can solve on their own and they decide to get the judge involved in it. How far should those orders go in disarming an individual, and what sort of due process should be afforded to that individual before we strip them of the inalienable right of self-preservation? And for that reason, Rahimi doesn't solve a single thing. It tells us what we already know. If society deems an individual to be dangerous, they can disarm them. And that is not new. That predates not only the ratification of the United States Constitution, it predates the Declaration of Independence. So ultimately, with very little usefulness for those that support the inalienable rights of American citizens, the Rahimi case, in all likelihood, is going to be nothing but a bunch of bad words that pop up over and over and over in briefs from California and Illinois and Washington and Oregon and New York and New Jersey and Maryland, which basically says, hey, this is something that happened sometime in our country, therefore it's relevantly similar and it justifies disarming people under this fashion. Listen, the case once again is United States v. Rahimi. We'll link it all up down below so that you can geek out on it for yourself. Maybe you got questions about this or anything else related to what's left of our Second Amendment rights. If you guys want to contact Washington Gun Law but don't know how to, don't worry. All of our information is right down there in the description box. Maybe you got an idea for a video we should be doing here. If you do, go ahead and click on that link right there. Most of the best ideas, candidly, we ever had here weren't really our ideas to begin with. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.